Hey everyone, Harry here. Welcome to another Substack Live and another Substack Live with the redoubtable Adam Klasfeld, who, as everyone knows, is really the man of the hour when the hour holds really big breaking news, particularly from big legal proceedings. So we have the ruling today in the Trump fraud trial brought by the Attorney General, Letitia James, that Adam followed. And then also the late breaking decision from the federal court, Chief Judge in the District of New Jersey, concerning Alina Habba and what the judge holds was an invalid attempt to appoint her as U.S. Attorney. Both of these are pretty damn tangled webs, but Adam is, and hopefully I, are pretty accustomed to trying to cut through to the real chase and the most important parts. So, Adam, welcome as always.
Thank you, Harry.
Shall we flip a coin? What tangled web do you want to weave first?
Well, I will point to a commonality of these two stories.
All right.
Alina Habba, who was Donald Trump's defense lawyer in the civil fraud case and started reacting to today's news there by saying something about it that wasn't true, that the court vindicated the notion that this was all a political farce to begin with, which was not a finding of any but one of the five judges on the panel.
And we're talking about the fraud trial now, not the ruling
The
on her.
civil fraud trial, correct. The whether her appointment was an illegal farce is something that we'll talk about later in the hour. But I would say it's a whirlwind day for her. I mean, she had something to celebrate here because we've got to be blunt. There's no way to describe a ruling that reduces Trump's civil liability from $500 million to zero other than a huge win for him, even if technically at this moment the findings of fraud against him survive. It was affirmed by the panel. It is sent up to the Court of Appeals. But within that, there's this stew of 300 pages. And if someone's trying to give you a kind of fortune cookie version of it, they're trying to spin you because it's very hard to untangle what these judges are actually saying. I'm going to try to break it down.
Well, actually, if you don't mind, break it down first because you were there. Just give us the elevator version of the trial itself before serving it up to what happened today.
Thank you for that, Harry. Yes, so I was there throughout Trump's civil fraud trial. So it was both notable for what happened in court and all of the theatrics in court, but what emerged in court and what remains undisturbed from today's ruling are some of the stories that a lot of the folks who are watching this have heard, which is, for example, the Trump Towers triplex was estimated as 3 times larger than its actual size. And when people were talking about the inflated values, when they're talking about the fraud at the heart of the case, they're talking about what's the methodology that you use? That wasn't factored into fraud. It was, did you physically overestimate the size of the property to give it a larger value? And in that particular case, Trump's defense has been, oh, that was an honest mistake. I put the wrong number there. And what emerged from trial is, well, Forbes ran a story sometime along when Trump was turning over what are known as statements of financial condition, or SFCs. He does it year after year. Then Forbes runs a story that says Trump has been lying about the size of his New York apartment. And the true size comes out. All of a sudden, the SFC, statement of financial condition, amends the size for the true size, but the price per square foot suddenly inflates. So it goes to why the judge, after this bench trial, after considering a lot of evidence that was presented by Attorney General Letitia James, had reached that ruling. And that was just a solitary example. There were
right. Right. Isn't that the case? So that's a very vivid example, because what are you gonna say? And that one, as I recall, is the one that actually ensnares Alan Weisselberg in a perjury conviction and the like, because he is involved and pretends he isn't. But this is, as I remember it, basically the Michael Cohen revelation, which is when you want to have high valuation, maybe you're looking to borrow, you inflate. When you want low, maybe you're looking to pay taxes or whatever, you deflate. And the result is affects what kind of rate you might get from a bank. And they were able to manipulate to get better rates than they otherwise should have received. The pitch from Trump was always, so what? We paid back the loans, really no victims here. And the retort from James that prevails at the trial level is, maybe not, but it's still the people of New York and the financial markets that get harmed. And when the judge agreed and came time to actually fasten on a remedy, basically took all the amount that they may have saved by manufacturing different rates, $500 million, and made it a disgorgement remedy, although that was the remedy for the fraud. And that was always quite the price tag. And people were wondering, would the Court of Appeals, reduce it, what they would do. And am I right that basically serves up the crazy stew that we got today with the 100+ pages of 3 different opinions?
Right. That's absolutely correct. And
Okay.
for folks who might be confused, how did they go from $500 million to
Yeah.
zero? It's because the penalty was disgorgement. And that means the ill-gotten gains, anything that you got as a result of fraud, must be disgorged, must be given back to the state because you didn't earn that. So one example would be Deutsche Bank. They submit these statements of financial condition that are inflating his assets, and he's a very wealthy man at this point. That he was, I think, a $2 billionaire. But in order to obtain the favorable loans, he needed to be a 2.5 billionaire, and he got that favorable rate. Now, what did he make as a result of inflating his net worth year after year by billions? He got and the judge systematically broke it down. Well, you obtained this favorable rate from Deutsche Bank. You were able to get this deal in Washington, D.C. on your hotel that you might not have otherwise gotten. And it went down the list. And that's how it added up, along with interest. So once that's a piece of the Jenga puzzle. Once they remove disgorgement,
Right.
because the Trump argument for the entire time had always been that, well, I paid my loan back to Deutsche Bank, no harm, no foul. However, it's the argument from the state has always been, what does that matter? You aren't allowed to profit from systematic serial fraud over a sustained course of years. And 2 of the judges were sympathetic to
the
that.
2 of the 5 judges today, and the
2 of the
appellate
5 judges today, not in terms of a penalty, but in terms of an injunction. They said, maintain the fraud findings, maintain an injunction that had barred Trump and his sons from participating in New York corporations for a period of time, installed corporate monitoring. It was very in-depth injunctive relief, but it didn't involve a monetary value. There wasn't a dollar sign next to that. That was what 2 of the judges would have upheld. two of the judges would have
So
called
let's set it, because we do wind up with a really confusing bottom line that's hard to know. But at least, so two say the fraud was legitimately brought, legitimately proven, etc. And then dealing, or maybe I don't mean to be preempting you, but they say the 500 million disgorgement. I'll just cut to the chase. That's an excessive fine, an unconstitutional, too big a fine, because although we call it disgorgement because that was the measure, really it was the fine for the fraud violation. They're saying that's excessive under the Eighth Amendment, under the federal Constitution and the state constitution, and they throw it out. They don't, as often judges would do, reduce it. They just say it's gone. So this is the best opinion for Letitia James. Two of the judges saying, yep, everything that she did was solid. It was a fraud. Their monitors should be there, etc. But goodbye, $500 million. And if that's the best for James, then it's pretty clear, as you say, Adam, this is a good day for Donald Trump and a not good day for Letitia James. But it gets worse from here, right?
Yeah,
So let's talk about the other three.
Right. And arguably a very bad day for the integrity of New York markets. Number two, so the two other judges, you have that they criticize the fact that the lower court judge before trial reached summary judgment on one of the counts. And because he reached that ruling that they disagree with, they feel there needs to be a new trial on all of the counts. But they go out of the way to say that they view the facts and the evidence. Similarly, they don't reach any kind of finding on fraud, but because there's no clear majority you have this weird split. They'll just affirm the verdict and kick it up to the state's highest court, known as the Court of Appeals. So they would have wanted a new trial because of their disagreement with a ruling that occurred before the trial began.
So is this as bizarre as it sounds to me? I mean, if they were the only judges there, and a judge at an appellate court says, "Oh, you made a bad ruling that infected the trial," that's a little strange here, because it's the same judge who was serving as the fact finder. But normally, you then send it back down, start again, or whatever. And here they say that much. But then when it comes time to state their conclusion, they do this weird kind of gear shift saying, nevertheless, just so an appeal can happen. This is the intermediate court, and the highest court, the New York Court of Appeals, would be next. We're going to state our bottom line, but it's a complete disconnect with our whole reasoning and everything that came before. There should be a new trial. This was a mistake. Affirm, right? Something
correct.
That's
absolutely right. I've never seen anything like this before in 2 decades. But then again, they also acknowledge this is a very weird circumstance, because one of the defendants is president of the United States. One of the defendants. There's also his children. There's also his companies. There's also his business associates. And that would create challenges for a new trial. And so the most efficient way to get this finally adjudicated is getting it up to the top court. So I've never seen anything quite like this, but that is the weird bottom line of their ruling. And
there's kind of two bottom lines, right? There's what they're saying should happen, but then there's just a sort of kind of power through to push things up to the Court of Appeals, just for very pragmatic reasons that are kind of divorced from there. That's what happened there, because there are 5 and no 3 are on the same page, right?
Correct.
And there's one judge left. What did that judge have to say?
And that judge does everything but call it a witch hunt. He is the most sympathetic to the Trump position. Mm-hmm. He criticizes Letitia James for her comments before it, and claims that it's a political case. He is the outlier in this. He would have dismissed it in its entirety, and he said as playing on the comments of the first two judges that I mentioned, that this is about market hygiene. He says this isn't about market hygiene. This is about political hygiene. So that's his turn
Which
of
was
phrase.
always the Trump. You were at there. I mean, that was day in, day out the Trump call. All right, let me see if I can go to the head of the class here, Professor Classfeld, and just summarize. But it sounds like headline: $500 million remedy measured as disgorgement is just gone totally, unless it's revived by the Court of Appeals. He is $500 million richer today. This was the whole thing with posting a bond, etc. That is cause for celebration at Trump Organization. But there is at least two, but it seems like technically there is a four-person holding that the fraud otherwise is valid, holds up, at least for purposes of going on to the Court of Appeals. And I guess we can assume Trump will appeal the part that he doesn't like, namely that it's still a fraud against him. James will appeal the part she doesn't like, namely the $500 million. So unless the Court of Appeals does nothing, we have a bizarre kind of makeshift ruling. But what it's really saying is, let's take both of these, let the Court of Appeals deal with it, and then we'll have a definitive ruling both on whether he's a fraudster and on whether he needs to disgorge or pay some penalty. Did I get that right?
You got that exactly right. And that's why you have both sides actually celebrating today's ruling. You have Letitia James coming out and saying that the court has affirmed the validity, that this is a case with merit, and that if you actually look at the only judges who grapple with the evidence, two judges wash their hands of it in light of certain legal issues regarding the summary judgment motion and the statute of limitations. And one judge is against the lower court's findings of it. So that is the kind of silver lining for Letitia James. And I'll also add, this comes in the...
But it's a little bit hollow, right? I mean, she's putting the best face on what will play as a not very good result for her.
Yes. I will add, because it's coming in this particular week when you have Ed Martin standing outside her house in a trench coat, it is worthwhile for her to point out that this was a case that is fundamentally the bottom line is affirmed.
The fraud part is valid. Ed Martin, go away with any claims that part was corrupt. All right, let's now you and I switch gears to this tangled web over on this other side that is in some ways equally labyrinthine, but not about New York law and disgorgement, but rather about, God help us, the Federal Vacancies Reform Act and how you replace U.S. attorneys. But here as well, we have a solid headline that is the thing really to grasp, and then we'll try to unpack it as well. But the headline of the District of New Jersey Federal Court opinion today:
Alina Habba's appointment as the top prosecutor of New Jersey is unlawful. She is unlawfully serving in that role. And this is why this is a whirlwind day for Alina Habba. It began with,
she was the lawyer, one of the lawyers in the fraud trial, right?
Yes, she was a key lawyer in the fraud trial. She went toe-to-toe with Michael Cohen. And she was one of the people arguing throughout. I wouldn't say that she was a lead attorney, but she was one of the main attorneys, and she's captured.
And she got crosswise repeatedly with the judge, right?
Absolutely. But I would say that was true of everyone on the defense team and perhaps even the defense table. This was a trial that was not short on theatrics. But the day begins with the overturning of the financial penalty and ends with a judge declaring that her appointment is illegal. And because this is a really important story for reasons that are even beyond Habba, because Habba is one of at least four people who Trump appointed to a U.S. attorney position after their temporary appointment. Remember, interim appointments are supposed to last 120 days. After
What's an
those
interim appointment?
The interim appointment is an appointment that has not been Senate confirmed or hasn't been ratified by the judges of a particular district.
Okay, so like there's nothing there. We need somebody in office. You put someone in for 120 days. Presumably, the political process then runs its course, except sometimes, as in this time, it doesn't. The 120 days comes to an end, and the Senate hasn't confirmed anyone. Okay.
Right, because during Trump's second term, we need occasional reminders that there are three branches of government.
Right.
And this goes to the appointments clause of the Constitution. And I've wanted to flag a particular line from this ruling that goes to
Okay,
the
and
heart
before
of
you
it.
do, this is me
Yeah.
being nerdy, a constitutional guy, because the appointments clause says specifically that Congress can make provisions for inferior officers, and U.S. attorneys are inferior officers. So it really is in their bailiwick. But now to the opinion. Yeah.
Right. So he points out why the framers had found the appointments clause to the Constitution so important. Said, quote, "The manipulation of official appointments had long been one of the American Revolutionary